Hi everyone, my name is Mildred Aguilar, and today I will be presenting on the Hogue versus Hogue case. This case has Maria Gwen Hogue, which is the plaintiff and appellant, and Jerry Dean Hogue, which is the defendant and respondent. So the court that the case was decided on was the California Courts of Appeal, decided on September 9th, 2017. So the main issue of the case was whether California had personal jurisdiction for a restraining order request based on the actions that the defendant had committed against plaintiff who was residing in another state. So when we talk about personal jurisdiction, it basically means, does the other party, so the defendant, have minimum contacts within the state that is requesting this motion? And if there is no personal jurisdiction, then the courts can decide whether or not they want to go through with the issue. So basically, here's a little bit of the background. So Maria Hogue had brought an action, restraining order, under the Domestic Violence Prevention Act against her estranged husband. Her husband, or the defendant, had contested against the case because it had lacked personal jurisdiction, and he stated that he had not any contacts with the plaintiff for over 2 years. So the commissioner originally hearing the case had quashed the restraining order requests based on the lack of personal jurisdiction. So they said that California lacked the personal jurisdiction to hear the case. So then the plaintiff, her name is Maria, then had appealed on the grounds that California did have personal jurisdiction over the case because the defendant's conduct comes across the special regulations basis for specific jurisdiction, as the act that the defendant had committed was in California when even after the defendant had left the state. Defendant had then stated that when the actions in which the restraining order was being requested on by the plaintiff, that at the time he lived in Georgia and had no longer had any contact with the plaintiff for over 2 years. Plaintiff had moved away from Georgia and moved to California shortly after filing the dissolution of marriage and restraining order. So the plaintiff was requesting a restraining order for herself, her mom, who she was living with in California, and her 2 dogs, which the defendant had committed abuse on before. So she stated in her declaration that there were certain incidences of abuse in December 2015 where the defendant had left 2 black eyes. And in the original opinion, it had actually said that he had choked her, which in reality he had strangled her to the point where she was almost unconscious. She also reported about 20 years history of abuse. So after the plaintiff had left Georgia, came to California, the defendant had videoed himself and intended to shoot himself in the mouth with a shotgun, and had put it on a video message on plaintiff's social media account in December 2015. So originally, the restraining order was quashed, again, because of the personal jurisdiction, and the internet abuse was only described by the plaintiff, and there was no grounds or evidence for request. So basically, all the claim or the motion had was for the physical abuse that had occurred in Georgia and the video that the defendant had sent out, even though the defendant didn't deny that he had sent out the video. So the Domestic Violence Protection Act in California had authorizes the trial court to issue a restraining order for the purpose of preventing a reoccurrence of domestic violence and ensuring a period of separation for the persons involved. That is the definition of the Domestic Violence Protection Act. So, again, if the affidavit shows to the satisfaction of the court reasonable proof of a past act or acts of abuse, then the restraining order is issued under the Domestic Violence Prevention Act in an independent action brought by a former spouse who has been in the subject of the abuse. Again, this is the California Family Code 6301. So because the defendant had purposely had sent the video of a mock suicide to the plaintiff in California, the case now being argued, the alleged abuse happened in Georgia. Conduct by sending that video would reasonably disturb the plaintiff's peace of mind within the definition of the Domestic Violence Protection Act and is the basis to grant the restraining order. So therefore, because of this incident, it was enough to grant the personal jurisdiction in the California courts over the defendant and prevent him from doing any acts of abuse and further, whether that is internet abuse, email abuse, any type of electronic abuse, and physical abuse, right? Because of the restraining order against the plaintiff. The reason why I chose this case is because, I am a domestic violence advocate, so this very much interests me because this is what the type of work that I do, and it shows that even, abuse is abuse, and whether it is that the person who's committing it, is no longer in the state, this is grounds that restraining order can be granted based on, maybe this case or any future cases that reference this case. So I think it's going to be moving in the positive direction to granting more restraining orders for people that are victims of any type of cyber abuse, any emotional abuse, etc. So this is why it interests me, and I hope you find this brief interesting as well. Thank you so much for watching.